Have you ever considered if the work generated by AI is protected? Let's ask Vilija Viesunaite, Trinity Eurex managing partner in Lithuania and head of intellectual property practice group. Vilija is a patent attorney and a European patent attorney having the right to represent clients in the State Patent Bureau of the Republic of Lithuania, European Union Intellectual Property Office, and in the European Patent Office. Vilija is also an arbitrator of Vilnius Court of Commercial Arbitration, where she provides services in the fields of information technology and intellectual property. During over 20 years of intellectual property law practice, Vilija has advised over 500 clients. Let's invite her on the stage. Hello, Vilija.
Hello, Andres.
I have a very important first question. Are
Go
you
ahead.
afraid of AI?
No, it's part of our everyday life.
Absolutely. So, have an amazing time here on the stage. The stage is yours.
You. It's a big pleasure. Good afternoon, ladies and gentlemen. Thank you for having me here and allowing me to speak on such interesting and important but still uncovered topic about artificial intelligence and IP. Intellectual property is the driving force of the future, and the future is not more imaginable without artificial intelligence. Therefore, this means that these two elements have to cooperate with each other and develop with each other so that the future is bright and that the future of our economical and social life is bright. But is it really so? The importance of IP protection was already discovered some 2,500 years ago when the recipes of the famous Italian, at that time known as Magna Graeca, cookers were granted protection for 1 year. And even Cicero referred to some plagiarism in his works and speeches. Since then, the importance of intellectual property protection was granted more and more significance on international and local level, because it is clearly understandable that it's the driving force of economic and social life. But don't be afraid, I'm not going to bring you to some history. And let's jump straight to early 50s when the AI was born, and where we have Alan Turing, who is meant to be as the father of artificial intelligence. And he said that if a human being is using some decision making, and if humans use available information as well as reason in order to solve problems and make decisions, so why can't the machines do the same thing? That was when the roller coaster with smaller or bigger hills of AI began. Another landmark in AI, in development of AI, was in 1997 when the World Chess Championship, Garry Kasparov, was defeated by IBM's product Deep Blue. And actually, that was the first match when the human being was defeated by artificial intelligence. And that was a big step forward to the decision-making of artificial intelligence. Afterwards, we have a voice recognition system prepared by Dragon system, and we even have a human census made by the robot, which was named Kismet. Now, the artificial intelligence is used in our everyday and is part of our comfortable life. Despite of that speed development, we are still under the very first steps in the legal world of artificial intelligence. And the legal questions are answered at the same time we're raised. Which means that we are learning together with the development of artificial intelligence. And the rise of artificial intelligence is marked by a great number of AI-related patents which are filed all around the world. And these are 5 companies having the biggest number of AI-related patents in the world. We have IBM, Microsoft, Google, Samsung, and Siemens, which develop their AI and seek for their protection. So, do we have answers? No, we have just questions. And the questions are, can AI be considered as the author of the copyrighted product or invention? Or who owns the right to the piece of the art created by artificial intelligence or with assistance of artificial intelligence? And even, can we use AI system without the infringement of other IP holders' rights? So these are all questions that we have to answer, and we'll try to do it today. So, can the computer-based system be creative? Since Berne Convention, we are made to think that it's only human being that can be a creative and can make a piece of art that can be original. So, but can the computer-based system be creative? When we talk about authorship in artificial intelligence, we have to talk about different things. First of all, we have to talk about pieces of art created solely by artificial intelligence, and pieces of art created with the assistance of artificial intelligence and with the presence of a human being. And meanwhile, the latter, there's no problem of patenting or protecting of these systems. There's a big problems with the authorship or for the pieces of art that are created solely by artificial intelligence. The general principles of copyright law imply that the copyright protection is applicable for an original work made by an author, which is fixed in some tangible medium, and it has to have at least a minimum amount of creativity. So, indeed, who can deny that it's only the Rembrandt that could create such piece of art? But what about this one? We have the next Rembrandt case here, and it dates back to 2014, when a team of Microsoft scientists, they merged their efforts together with some group of 3D printing specialists. They put a lot of data on Rembrandt's paintings and Rembrandt's friends' paintings. The data focused on specifics of the Rembrandt's paintings, and the machine created the picture that we have on this on the lower part of the slide. So, of course, there's no argue that behind this project there's a group team of human beings. But as a painting was created just by the machine, who owns the copyright to it? Is it a group of human beings, or is just the machine, just a computer? And the next example of AI-generated piece of art is AI-generated poetry, which was created for the World Poetry Day, and it was on the stage in 2019. Is it original enough to be copyrighted and AI to be named as the inventor of, or as the poet of this poetry? Actually, the general opinion is that no copyright protection can be granted to computers, as they are not encouraged to create new works, and they don't understand the novelty and applicability of their works. And these arguments are backed by the European Court of Justice arguments in Infopak case and in the case which is called Bezpieczności Software'owa Associates. Sorry for my French. But these two European Court of Justice decisions, they said that no copyright protection can be granted to the pieces of art created by the computers. And then we come to the hottest topic of today, which is called DABUs, or patenting of AI-generated inventions. We come to August 2019, when a group of scientists filed applications for two inventions. One invention was dedicated to some signaling thing, and another invention was dedicated to the food container. The main feature of these inventions is that they both were made by AI-generated system without any intervention of a human being. Dabus was named as the inventor of these two inventions. Actually, now this the patent application was filed in European Patent Office. It was filed in the United States and in UK. Now the applications are filed in around 20 jurisdictions. Some of them are still pending, waiting for the decision which is going to be made. So the main feature of these applications or of these inventions is that there was no human being intervention of making them. It's only system, the computer-based system that made them. That's why Dabus was called an inventor. So is Dabus an inventor? And can Dabus be called an inventor? It should be emphasized that the designation of an inventor is mandatory in all patent applications. Meanwhile, the group of scientists who filed applications for these two patents, they made a good thing, or they made an interesting thing. They did not mention Dabus as the inventor at the very first step while filing the application, which is also can be done according to the regulation. And only once the patent offices of United Kingdom, United States, and European Patent Office decided that the inventions themselves or itself, they are new, they have some prior art, and they can be they are patentable, only then the group of scientists named Dabus as the inventor. And what happened then? Then the patent offices, they refused these applications on the ground that the concept of the inventor is limited only to human being exclusively, and there was no human being indicated as the inventor in these applications. So the registration was refused. The inventor must have a legal personality, and the AI system does not enjoy legal personality as human being does. However, the patent was granted in South Africa and Australia. It happened rather recently. It made quite a shock in the patent world. So these countries are the first countries in the world that granted patent to some invention that was made by, not by human being, but by artificial intelligence. We could think of this as a very strong landmark in the patent world, probably promising that an artificial intelligence system can be named as the inventor and be an inventor of the invention in the future. However, this is not the case, because in all the other countries, or in most other countries, just the wording of legislation is referred to the human being. They use such phrases as who, someone, so that they refer to a live person, but not the AI system. And that's like a very formal cause why AI cannot be named as the inventor. The case in European Patent Office is still pending, because the refusal to grant the patent was appealed, and the court hearing, the hearing is scheduled for December this year. so it's quite soon. We may expect some shock, but it's hardly to be believed to be a shock, because the current position of the European Patent Office is also backed by some European legislation. We have a European Parliament resolution on intellectual property rights, which clearly said that the ownership of property of rights should only be assigned to natural or legal persons that created the work lawfully, which means that only human being can be granted the copyright protection, copyright rights to the invention that was made. So the shock is highly doubtful, but what's next? If miracle happens and EPO suggests that artificial intelligence can be named as the inventor, then most likely the laws of many countries should be changed, and those changes should be introduced rather soon. But if not, what if EPO keeps its position by saying that, well, original work can be created only by a human being? What about business? What about business who is interested in investing in artificial intelligence? And will this business be still the same eager to invest in further artificial intelligence technologies and development of artificial intelligence technologies? How business should protect their rights to those objects, and how they protect their investment. Somebody may say that this is a question of the trade secret, but it's not, because now the reverse engineering is that good that the way out can be figured out rather quickly. But there is also another side of the story. When we talk about inventions made by artificial intelligence, we have to think about inventions made by human beings. And there is no question that artificial intelligence may produce inventions and create things that will develop rather quickly. And inventions developed by the human being will be left behind, which means that there could be one day that the invention made by a human being is not longer patentable because it's not new, it has no prior art, or it's not useful in the industry. I do believe that it may cause some troubles for our human generation. But let's wait for EPO's decision and see what happens next. Another thing that we have to consider while talking about artificial intelligence is copyright infringements made by artificial intelligence. Can we use AI system without the infringement or the other IP holders' rights? And we have, let's say, IBM's face recognition system, which was fed by the photos taken from a picture database, which is called Flick. So what about rights to those photos? Can those photos be fed to AI tool without the consent of the owners of the photos? Can AI tool be used afterwards without the consent of the photos owners? And can other businesses use that tool made by AI without the consent of the right or the primary IP right holders? That's a very important question, and we have some problem here, because there is difference in EU regulation and regulation in other countries. Let's say United States treat this as a fair use. Japan changed their laws. Meanwhile, the wording of Digital Single Market Directive is not that clear, And frankly speaking, I believe that we may consider this as an infringement according to European Union law. Therefore, if European Union is eager to strive for better development of AI tools, they have to change their laws. And we have some optimism here in the draft of the Artificial Intelligence Act. I'm not going to read it loud, but yes, EU think that we have to strive for competitive advantage to companies and the European economy when we talk about artificial intelligence. Thank you very much for your attention. I invite you to drop me a line or to just call me, and I'm ready to discuss these questions more deeply with everybody with you. And meanwhile, have a very, very nice rest of the day.
Thank you, Vilija, for an amazing keynote presentation that you just did. And I do have one question to ask. Are there more reasons for AI not to be an inventor?
Well, that's a good question. And people say that it's a problem with the general title or ownership to the invention. Because there have to be someone who owns the invention. And if it's a human being, it's understandable. If it's a legal entity, it's understandable. But if it's a artificial intelligence, can it own the invention and the patent invention? Can it transfer to somebody else? Can it sign this assignment document? That's the main question that we're discussing now.
Okay, thank you so much for your answer. Ladies and gentlemen, that was Vilija Viesunaite, Trinity Eurex Managing Partner in Lithuania and Head of Intellectual Property Practice Group. Thank you so much.
My pleasure.